Thank you so much, Mark, and Chairman Green. It was such a privilege to cap off my congressional career working for you and the American people on the impeachment proceedings, and I just thank you so much.
Yeah, thanks for being.
I was actually involved in 2 impeachments in my career as a congressional staffer, President Bill Clinton and DHS Secretary Mayorkas. Upon evaluation, I consider the Mayorkas impeachment the more compelling. One involved what the meaning of is. The second involved what the meaning of American sovereignty is and what the point is of Congress passing laws if the executive branch chooses to flout them. As Paul indicated, the catalyst for the House's extraordinary action was a decision by the Supreme Court last June. The decision, U.S. v. Texas, dramatically altered the balance of power between the executive branch, Congress, and the states in instances where the executive branch chooses to less than fully execute the immigration laws of the nation. The decision left the House with little choice but to impeach Alejandro Mayorkas, at least should it desire to preserve its constitutional prerogatives and protect the states from the disastrous consequences of Secretary Mayorkas' willful and systemic refusal to comply with federal immigration law. As Chairman Green's committee report on the impeachment noted, the Supreme Court agreed to hear a case involving the very same unilateral suspensions of the federal immigration laws by Secretary Mayorkas that are at issue in this impeachment. Mandatory detention of criminal aliens and other aliens in the U.S. unlawfully in certain instances. The Fifth Circuit concluded that Mayorkas' actions had every indication of being a general policy that is so extreme as to amount to an abdication of statutory responsibility, and that the replacement of Congress's statutory mandates is plainly outside the bounds of the powers conferred by the Immigration and Nationality Act. Secretary Mayorkas' actions and beliefs have disturbing parallels to those alleged in the congressional investigation of the Reagan administration's so-called Iran-Contra affair. 2 congressional committees, 1 House, 1 Senate, took part in the investigation, finding that certain administration officials displayed disdain for constitutional processes and the legislative branch. When Congress disagreed with these officials' deeply held beliefs, they allegedly decided to ignore the duly enacted laws passed by Congress. The committees concluded the common ingredients of the policies were secrecy, deception, and disdain for the law. A small group of senior officials believed that they alone knew what was right. In the Iran-Contra affair, officials viewed the law not as setting boundaries for their actions, but raising impediments to their goals. When the goals and the law collided, the law gave way. The committees went on. Former officials lectured us that a rightful cause justified any means, and that Congress is to blame for passing laws that run counter to administration policy. What may aptly be called the cabal of the zealots was in charge. Government officials must observe the law even when they disagree with it. These were the Democrat-led committees investigating the Reagan administration. Independent counsel Lawrence Walsh, who did the criminal side of it, concluded that the crimes committed in Iran-Contra were motivated by the desire of persons in high office to pursue controversial policies and goals, even when the pursuit of those policies and goals was restricted by statutes or the constitutional system of checks and balances. Secretary Mayorkas has apparently come to the conclusion that he and his cabal of the zealots alone know what is right, alone have a monopoly on the truth. DHS detention, they've decided, is morally inexcusable, and the law has to give way to mass release by any means necessary, especially because Congress is to blame for passing mandatory detention laws in the first place. I'm frankly surprised the Secretary hasn't chained himself to a building at Columbia University yet. To those who say Mayorkas was just carrying out orders, let me quote independent counsel Walsh. When a president chooses to skirt the laws or to circumvent them, it is incumbent upon his subordinates to resist, not join in. Their oath and fealty are to the Constitution and the rule of law, not to the man temporarily occupying the Oval Office. Paul has very well explained the basis of the impeachment in the U.S. versus Texas decision. I should just raise a few points which were raised in opposition to the impeachment during markup on the House floor, things of that nature. A lot has been made of the fact that Justice Kavanaugh's opinion itself does not actually contain the word impeachment. Representative Glenn Ivey argued at the markup that the chairman and others have made the point that the only remedy available is impeachment. That's not what Kavanaugh wrote. He does not mention impeachment. The articles of impeachment rely on Justice Alito's language. He's the sole dissenter in this case. However, Justice Kavanaugh clearly understood impeachment to be one of the arrows that his decision left in Congress's quiver. Paul has explained what happened at oral argument, and Secretary Biden's Solicitor General saying that dramatic abdication of statutory responsibility that can warrant impeachment. Senator Schumer justified his unprecedented and irresponsible dismissal of the House articles by claiming they're constitutional. He might have first checked with President Biden's Solicitor General as to that view. It's not even accurate to say that Justice Kavanaugh's opinion itself doesn't touch on impeachment. In the opinion, immediately after writing, for example, Congress possesses an array of tools to address executive branch misdeeds, he referred to two Supreme Court cases and two specific pages in those Supreme Court cases. Well, what did those decisions say? The first, a 1997 decision, Raines versus Byrd, on the page referenced by Kavanaugh, it said the Tenure of Office Act provided that an official whose appointment to an executive branch office requiring confirmation by the Senate could not be removed without the consent of the Senate. In 1868, President Johnson removed his Secretary of War. Within a week, the House of Representatives impeached Johnson. One of the principal charges against him was that his removal violated the Tenure of Office Act. That was the page specifically referenced in Justice Kavanaugh's opinion. In the other opinion from 1993, the court, on the page referenced by Kavanaugh, stated that we hardly need to note that an agency's decision to ignore congressional expectations may expose it to grave political consequences. And what is more grave than impeachment? Columbia University professor Philip Bobbitt has argued that the Republicans misread Justice Alito, that he wasn't embracing impeachment as an alternative, he was trying to hold it back. Bobbitt also said it's a travesty, the impeachment, because it completely turns Alito's opinion on its head. He is not coming out for interbranch warfare. Professor Bobbitt totally missed the point. Of course, Justice Alito was not coming out in favor of interbranch warfare. Rather, he said ruefully that the court now says that no party injured by this policy is allowed to challenge it in court. So in the terrible situation into which Justice Alito believed Kavanaugh's opinion had placed Congress and the states, quote unquote, disruptive measures such as impeachment were the quote unquote only limit on the power of the president of a president to disobey the law. In Representative Dan Bishop's paraphrasing of Alito, I don't think this is a wise decision to make, but that is the decision the majority made, and if you want the law to be followed, you're going to have to impeach somebody. That's where Justice Alito was. Justice Kavanaugh put the House in the position of having to bring impeachment proceedings. That was quite a June swoon for the Kavanaugh court. Justin Driver, a law professor at the University of Chicago Law School, has written or wrote before Kavanaugh's confirmation that a dominant narrative of the Supreme Court during the last 5 decades has been the apostasy of Republican-appointed justices. Kavanaugh's confirmation would almost certainly spell the end of that storyline and cement a generation of GOP constitutional orthodoxy. Well, reports of the death of the apostasy story have been greatly exaggerated. As David Savage wrote in the LA Times, The crucial battle these days within the Supreme Court are among its 6 conservatives, not between them and the 3 liberals. The outcomes in close cases now turn most often on one justice, Brett Kavanaugh. Twice, Kavanaugh played a key role in upholding Biden's immigration policies against lawsuits brought by Texas Republicans. And that is what brought impeachment to the House floor. Thanks.